The Citizenship Act 1955. The Part 2 of the Constitution of India contains provisions that cover the acquisition of citizenship at the time of commencement of the Indian Constitution. That is 26th November 1949. Article 11 of the Constitution gives Parliament the power to make laws on the citizenship of India to deal with future scenarios. Now, the Citizenship Act was enacted in 1955 to decide on the acquisition and termination of Indian citizenship for those instances which were not covered in Part 2 of the Constitution. Deriving its power from Article 11 of the Constitution, the Parliament passed Indian Citizenship Act 1955 to decide the conditions for citizenship. While every person residing in the territory of India automatically became its citizen on 26th November 1949, the criteria set out in the Constitution could be used only for a limited time frame. Therefore, keeping in mind the need to have a flexible citizenship law to keep up with changes in the social, economic, and political conditions of the country, the Constituent Assembly gave Parliament the power to decide on the conditions to be met for citizenship. The objective of the Citizenship Act is straightforward. It is to decide how citizenship of India will be determined in the days after the adoption of the Constitution. This Citizenship Act of 1955 is a short act with 10 sections and 3 schedules. The Act was amended in 1986, 1992, 2003, 2005, 2015, and 2019, the much debated Citizenship Amendment Act. There are 5 ways to acquire Indian citizenship: by birth, by descent, by registration, by naturalization, and incorporation of territory. Now, these provisions are dealt under section 3, 4, 5, 6, and 7. So let us study every section individually. Section 3 allows for citizenship by birth to every person born in India between 1950 and 1st July 1987. The 1986 amendment, that is the first amendment to the Indian Citizenship Act 1955, restricted these provisions by adding that at least one parent of those born after 1986 must be Indian. In 2003, another amendment added one more restriction by saying that both parents must be Indian, or one parent must be Indian and the other must not be an illegal migrant. So we see section 3 deals with the provision with respect to acquisition of citizenship by birth. Section 4 deals with acquisition of citizenship by descent. Section 4 allows for citizenship by descent, which means that a person who was born outside the territory of India can acquire Indian citizenship if either of his or her parents is an Indian citizen at the time of his or her birth. There are further qualifications to acquiring citizenship by descent, which involves having to register the birth of the person at the Indian consulate and other conditions as the central government may direct. Section 5 allows citizenship by registration. Registration is the means to claim citizenship from one's own country when they have not been given citizenship due to various reasons, such as having lived abroad despite ordinarily being a resident of India. This is also available to a person who is married to an Indian citizen. This provision is available to persons of Indian origin, and a person can register as a citizen only when he or she is not an illegal migrant. It is mandatory for the person applying for citizenship through this route to have resided in India for 12 months before the application and for 6 years from the preceding 8 years in order to make such an application. Next, let's deal with Section 6. The Section 6 allows for citizenship by naturalization. This provision is available to foreign nationals who want to become citizens of India. The application process for this is similar to that of registration, but in this case, a person must have resided in the territory of India for 12 years with 12 months continuous residence before applying for citizenship. And finally, Section 7, which deals with incorporation of territory. Now, Section 7 provides for citizenship through the incorporation of territory to India. This means that if any geographical territory is added to the territory of India, then the central government can notify which persons from that territory will become citizens of India. Section 7A, 7B, 7C and 7D were added through the 2003 Citizenship Amendment Act, which provides for acquiring and renouncing overseas citizenship of India. The OCI cards were introduced based on the Indian diaspora's demand for dual citizenship. The Indian diaspora are citizens of India who have settled abroad. Now, the OCI card allows for relaxation of restrictions imposed on non-citizens such as visa entry requirements and restrictions on acquiring property. So this together constitutes what is the Citizenship Act 1955. Now let us discuss the amendments. The Citizenship Act 1955 has been amended several times. These amendments were based upon changing political, social and economic conditions of the country. The important amendments were the 1986, 2003 and the latest 2019 Citizenship Amendment Act. The 1986 Act put in restrictions on the acquisition of citizenship by birth. Now this we have discussed extensively. The 2003 amendment, it created provision for the overseas citizen of India that led to OCI cards. And then the 2019 amendment allows for the acquisition of citizenship by 6 persecuted religious minorities: Hindus, Parsis, Sikh, Jain, Christians and Buddhists from Pakistan, Afghanistan and Bangladesh. The Citizenship Amendment Act 2019 has also been criticized. The CAA Act sought to help illegal migrants who came to India before 31st December 2014 from Afghanistan, Pakistan and Bangladesh to apply for Indian citizenship via a faster route if they are Hindu, Christian, Sikh, Jain, Parsi or Buddhist. Many criticized the new changes as being unconstitutional and discriminatory as Muslims were not listed in the Act. Protests broke out across India. Critics say that Citizenship Amendment Act 2019 violates Article 14 of the Indian Constitution. Article 14 guarantees right to equality to all persons. Critics also argue that this concept is part of the basic structure of Constitution and hence cannot be reshaped by any parliamentary laws. The citizenship law of any country is fundamental to its being, as it is the citizens who have all the rights that a country grants and are required to perform the duties that a country expects from them. The subsequent amendments to the Citizenship Act have moved from the principle of jus soli, that is, persons of the soil, which is the right of any person born in the territory of a country to get citizenship, to jus sanguinis, that is, right of blood, which is the determination of citizenship of a person based on the citizenship of his or her parents. The Citizenship Amendment Act 2019 is particularly important because it marks the shift from both jus soli and jus sanguinis principle of citizenship to the provision of citizenship based on religion. The provisions of this act and its impact have been written about extensively. While it has been called divisive by some, others have heralded it as an accommodating legislation that offers religious minorities